5 years has been acknowledged by almost all national media, including members of Congress, as they debated the National Shield Law, as being a model for shield laws in all other states. 5 years ago, through the help and assistance of the then Attorney General, the Governor, and members of the legislature, both in the House and the Senate, through 3 months of discussion and compromise, we were able to draft and thereafter enact and have the Governor sign what I just told you was considered to be a model for shield laws. At the last second, unbeknownst to many of us, and we still do not know why, the chair of the Senate Judiciary Committee at the time, Brian Taniguchi, inserted a sunset provision, which meant that the law would expire in 3 years unless otherwise extended. 2 years ago, a bill was introduced first in the House to delete the sunset provision, no other changes, and came to the Senate before the same Senate Judiciary Chair who we believe is the sole reason for the defeat and the demise of the Shield bill. Senator Hee, on his own at the last second, without any input from the media, decided that he would not pass out a bill that would delete the sunset provision, but instead would extend the sunset provision for 2 years to allow the court to weigh in on whether they believed the Shield law was or was not something that they wanted to live with, because of course it's an evidentiary matter as to whether a reporter testifies or not in court. We were okay with that, and it was sent to the judiciary. After 1 year, and this is a public record available to all of you, the committee, which comprised judges, prosecutors, defense lawyers, civil lawyers, member of the AG's office, former faculty professors at the law school, passed out a report in which it unanimously stated that they were in favor of the existing law and the sunset provision should be repealed. It then went on to say, however, that there were a couple of issues that if the legislature wanted to look at, they could look at, and that was primarily because of the Attorney General's office, who had raised some concerns. What's critical and why the legislation passed by the Senate is so deceitful is that in the preamble of that bill, it states that the changes that they have made were at the request of the Judiciary Committee. That is an absolute falsehood, because the significant changes that the Senate version, which passed the Senate yesterday, had nothing to do with deleting from the statute non-traditional journalists and redefining who's a journalist and who isn't. That was not even in the things, if you want to look at, please look at. So they have manufactured a reason saying that they're simply adopting recommendations made by the Court Judiciary Committee. And frankly, read the report, it is absolutely false. So we come up to this session, and the first go-around goes through the House, and at the last second, with no input, this is critical for all of you, not only for this bill, but for other bills, the lack of input that the media was given. They were given virtually no opportunity to have any formal input. We were never invited to meet with the chairs of either the House or Senate Judiciary Committee. We were never invited to meet with the Attorney General. We did have one meeting, which the three of us requested and had early on. But in all the past few months, when all the political machinations were going on, no media representatives, none of our organizations were invited to participate. So everything was done without any input from the people who benefited from the statute. That's the critical thing for everyone. This is a statute that benefits a limited group of people and also the public, but it is for journalists. And to not allow or permit the journalists to participate in the process is outrageous. Anyway, the House chair, on his own, not having asked any questions when we tried to testify, put in a couple of changes. One, significantly, in the present law that will exist for another 2 months, civil cases were exempt from any attempt to obtain confidential information, except in defamation cases. The chair, saying that he was following some suggestions that were thrown out by the Judiciary Committee, suggestion is not the right word, but things they may want to look at, he put civil cases back in. And he added a few other criminal cases in which the reporter's privilege would not be absolute. It would be a balance. We didn't like it, but we met with him after, and he explained that he thought that these were appropriate changes, but he would never agree to any other changes, including the deletion of non-traditional journalists. You guys were there, and we heard it.
Non-traditional journalists and unpublished information.
The bill then went over to the Senate, and this is where all of the damage has been done. In a hearing that one can only call a joke, the Senate chair, obviously out to get the media, scuttled the House version and came up with a version that made the law, if it passed, not one of the best in the country, but worthless. Virtually one of the worst. It deleted all of the protection for anyone who doesn't work for pay for a paid, printed, or broadcast publication. So it deleted the Sun Press, the Civil Beat, in my opinion, Honolulu Weekly, the Huffington Post, Ian Lynn, the Hawaii Reporter, all of the 21st century media. And it took out any privilege for unpublished information, which is critical. We were given zero input. The hearing was a joke. It was intimidating. And so subsequent to that, we tried to send communications to various legislators, letting them know that it was totally unacceptable. And we come down now to the last few days. We had communications primarily with Scott Saiki in the House over the last couple of days. Went to conference committee, and a couple of things got moved back in, some things didn't. But the bill that was before the House and the Senate up until 2 days ago put back the protection for unpublished information, but essentially set up a divide between traditional journalists and so-called non-traditional journalists. It gave protection, it left the protection in for all of you folks, most of you folks, and took out the protection for all the organizations that I just mentioned, plus everyone else who blogs or may have a website that they believe is involved with the news. We offered repeatedly to sit down and try to figure out a way to make certain people's concerns addressed, and we were rebuffed. We were given zero opportunity. We learned about meetings between Clayton Hee and the AG. Clayton Hee said he was getting input from the ACLU. You now know the ACLU has come out publicly and said they had nothing to do with Clayton Hee's version of the bill. We've yet to hear from the Attorney General as to how much input his office had. We believe they had some, but I'll leave that to other people to determine. The group was not unanimous, the Shield Law Coalition, as to the present version that came out of the conference committee. Some of the more traditional media in town said, we don't like it, it's nowhere close to what we have, but if this is all we're going to get, we'd rather have it. The overwhelming majority of people in the coalition said this is worthless and we'd rather have nothing. So now, it's ironic, we can't work to save the present bill the present statute, we've got to work to defeat the proposed bill. Now, not everybody agreed with that, but that was the overwhelming majority. Society of Professional Journalists, Media Council, AP, Civil Beat, I can go on. But some of the more traditional media said, we don't like it, but it's better than nothing. We got in touch with the House, with Scott Psyche, and I give him tremendous credit, and I give the House tremendous credit for its guts. It may have been late, but they did the right thing. We proposed, listen, don't kill what is the best law in the country without more discussion and more analysis, more input from all the people that may be involved, the courts, the media, the public, the legislature, the governor, the AG. Is there a possibility of extending the sunset provision 2 more years to give us a chance collectively to try to save the present law, or at least keep it so that it doesn't become a 20th century anachronism? The House, to its credit, yes, on short notice, apparently agreed, and in caucus yesterday, after having informing the Senate, because some members of the Senate said they were clueless, and we know that they were informed. Their leadership was informed. What the leadership told the other senators, I don't know. I was not there. But I have been assured by people in the House that the Senate was advised the night before and yesterday morning that they were going to amend the bill to extend the Shield Law for 2 years and to set up a study group. We were very happy. Even the media that were in favor of some bill versus no bill absolutely supported this as the best possible option. So it was unanimous. And then we waited for the Senate, and who we thought were some of our allies in the Senate, to introduce a similar amendment. And yesterday was a roller coaster ride. I'm not a real expert on how things work around here, but I'm learning, unfortunately. But in the end, not one senator was willing to stand up to Senator Hee and propose the amendment that had passed the House unanimously. And so I'm told behind the scenes they were, what word do I want to use? Let's just say they were told not to introduce the amendment, that there would be repercussions, that it wouldn't pass, that they had the votes, the Senate, to pass their version of the bill. Some claimed that they had been misled by the House was grandstanding. It's outrageous. The House showed tremendous courage. And so did the 9 senators yesterday who voted against the Senate version. There were 4, and this to me is very curious, who voted yes with reservations, which is a worthless vote. It's a yes. But if those 4 had stood up like the other 9, 13 votes would have defeated the Senate version. And we would still have a Shield Law. A Shield Law worth having. So as we sit here today, because primarily I am convinced of this, of the dislike and distrust of Senator Hee and probably the Senate leadership for the media, they have taken one of the best Shield bills laws in the country, tried to turn it into a law that was a throwback, and as a result, it's going to sunset in 2 months. Those are my remarks, my opening remarks, and actually my closing remarks. There have been some questions about whether my group will now in the next session attempt to go back. I think it's clear to say that as long as the present chair of the Senate Judiciary Committee remains the chair and the present leadership in the Senate remains, it's not an effort that I can endorse. I think it would be a total waste of time. We have spent so much time this year trying to bring rationality. But when the Senate chair holds up Dewey defeats Truman as an example of how journalism is, you know that you don't have a chance with somebody who's not willing to understand, first, that the Shield Law has nothing to do with truth or falsity. The Shield Law did not protect the journalist from bad journalism. It did not protect the journalist from defamation, our law. What it did is protect the journalist who gets information that is so important to the public from people who do not want their identities disclosed. There would have been no Watergate. There are a number of cases in Honolulu and in Hawaii now that people don't even know about, where because of the existing Shield Law, stories have come out that probably would not have come out without a Shield Law. And my advice is we don't need the legislature anymore if we're going to be treated this way. We'll go to the courts. We had some success in the courts before 5 years ago, but because of a number of factors, people wanted a statute that would make things non-dependent upon an individual judge. But the Senate version of the Shield Law is an abomination. And we are so proud of the House, but we are so sad. And when the national people find out about it, it will cast another negative aspersion on this state government, coming after Stephen Tyler and that joke in the Senate that even the New York Times editorialized. Wait till they get a hold of what's happened here on the Shield Law. Jerry, you're the big blogger guy.